Good morning, everybody. I am Julie Barn, the head of the employment team at Sharpe Minds, and today is our second session in our series on disability rights. And today, David and Medina are looking at direct, indirect discrimination and harassment. So quite a lot to get through. For those that have experienced employment tribunal claims, direct discrimination appears to be put in nearly all claims for one reason or another, and is probably the hardest for an employee to prove. Indirect discrimination is thrown in and very rarely understood, and harassment is probably the easiest type of claim for an employee to prove because it's based on their own feelings. So I think on that note, David and Medina will lead you through this session. If you've got any questions, please put them in the chat or the Q&A box. We'll keep an eye on both, and or you can wait till the end and ask them. This session is being recorded, and so if you can remain on mute throughout the session unless you want to join in and lead, which obviously we will listen for a while, and then we can go from there. But without further ado, David, do you want to crack on?
Thank you, Julie. So if we can just move to the next slide. So yes, so obviously this is number 2 in our series. So next month is reasonable adjustments, and we've already done defining disability and employers' knowledge, and obviously that has been circulated, and if you would like a copy of that, obviously please let us know and we can make sure you have it. Now, just before we move on, obviously the main thing is we are looking at a focus of disability in this, but obviously discrimination, certainly the first 2 elements, and certainly direct and indirect, does apply to all protected characteristics. We're just looking at disability as the main one here because it's usually the one that's quite complex for employers. So it's just something to be aware of, that you can pretty much substitute disability for any of the other protected characteristics. So next slide, please. So today we're just going to have a quick look at the legal definition of what direct, indirect discrimination is, and what harassment is, and certainly looking at that because, as Julie said, employees do bring that quite often and don't really understand it as much as I think they could. Then obviously looking at what this means for employers and managers with a couple of case law examples, and then some practical steps to help employers navigate this sort of scenario. So next slide, please. So what we're actually looking at, what is direct discrimination? Well, that is when a person A does something against person B because of a protected characteristic and treats them less favourably than they would treat others who don't have that protected characteristic. So the key point there is it's a direct action by one person to another, and also it's because of a protected characteristic. And I think that is probably, as we're looking forward, the key point to really look at anything when it comes to discrimination is it's because of that protected characteristic. And I think we can all say, we've seen instances where someone doesn't like something and then they say it's because of my race, my gender, my sexual orientation, or my disability. And that's where a lot of employee claims fall over, is they can't prove that it's because of that protected characteristic. Next slide, please. So just quickly covering disability discrimination and discrimination in general, who it actually protects and covers. So obviously employment, individuals in, employees is the obvious one, workers, anyone on occupational training, and it kind of protects them against obviously all discrimination, victimisation, harassment. We're not covering victimisation in this session. That is the 4th session of this series, but it's just part of the course of what's really covered. So it's a wide remit of who's covered by this sort of protection. So it's just something to be aware of. It's not limited to a very small number of people. And obviously it was talked about in session 1, this is a day 1 right. So you can unfortunately discriminate someone on the first day of their employment and suffer a claim, and you can have discrimination before the employment starts as well. So it's something to be very aware of. And I think, as most of us can see with our cases now, people are getting cannier at bringing sort of claims around the old style of something happened in the office, it's discrimination. It's getting bigger. And there has been recent changes in the law as to who can bring discrimination claims in relation to indirect. And we'll talk about that shortly. So just quickly, next slide, please, Andrea, looking at types of kind of discrimination, just as a way of examples for what people can see. So treating a job applicant differently because they have a disability, for example, you don't promote someone who has a learning difficulty, or you don't promote someone who is in a wheelchair. Now, those are very obtuse, gross examples. That still happens in some workplaces, but obviously most employers, they have robust processes that actually the correct applicant or the correct person is promoted based on merit, and looking at things like that. Now, one of the things to look here is there are elements when you can what's called positively discriminate against someone, and that, for example, is putting stuff in place for a disabled employee to make it easier for them. That is positive discrimination elements, treating them more favorably than a non-disabled person. That is allowed when it comes to a disabled person. Also, you have the scenario of where you've got two people going for a job. They are equally matched on all points. They are both equally qualified. They are both have the same experience. They tick all the boxes when it comes to how these people are on paper. But you can then look at the diversity statistics, and only then look at the diversity statistics. It must be the very last thing. And you might know, well, we don't have enough people, we don't have enough female employees at this level, so we're going to promote her over him, for example. But that must be the very last thing you do. You can't go into that process going, we need more women at the top, or we need more LGBTQ people at the top. If you can't promote on that, that's unfavorable treatment for those who haven't got it, because it's not based on a merit system. And kind of looking at the whole EDI argument in America at the moment, that's kind of how they have been doing it. They have put people in there based on characteristics, not sorting out the problem, which is if people who have characteristics that are underrepresented, why are these people underrepresented, and trying to actually solve the problem of education and training, not actually just putting someone there because it ticks a box. So just be very careful at looking at things like that. And if you are looking at situations like that, I'd strongly take advice both from HR and employment lawyers to make sure that you're looking at things correctly. Obviously, one thing we're going to go on, indirect discrimination. So you're applying a PCP, provision, criterion, or practice, and it disadvantages a certain group of people more than it disadvantages, or gives advantages to others. And I think the big one, is the pre-employment health questionnaire. Now, those are important in certain roles, but it should be at a later stage of the recruitment. They've already got through, they've been offered the job, and then they're given that. Obviously, it can still cause problems, but it shouldn't be a reason to hire someone or offer someone a role. So these are things just to talk about. And next slide, we're going to be looking at knowledge of a disability, and I'm going to hand over to my colleague Medina, who's going to start. Thank you.
Thank you, David. So essentially, an employer cannot be liable for direct discrimination or discrimination arising from a disability or a failure to make reasonable adjustments unless it knew or should have known about the employee's disability. An example of this action or in practice can be seen in blind recruitment practices, where managers have only specific details of employees, such as their skills and experiences, without identifying information like their names or other personal information. This approach can help select candidates based on their merits, avoiding unconscious bias that might arise from personal information that could reveal an individual's disability. So employers can also have implied knowledge of a disability. For instance, if an employee has a long sickness record before joining the practice, this can be a reasonable indication that they might be an underlying health condition. Employers must be cautious in such cases, as implied knowledge can trigger the need for reasonable adjustments or support, even if the disability hasn't been explicitly disclosed by the individual. Next slide, please. So essentially, an individual claiming direct disability discrimination must show that they've been treated less favorably than a real or hypothetical comparator whose circumstances are not materially different to theirs, and that's under Section 23(1) of the Equality Act. They must show a relevant circumstance, as in the case of Cordell and Foreign and Commonwealth Office. In this case, the AT held that a non-disabled employee with children was not an appropriate hypothetical comparator for a direct discrimination claim. This involved an applicant who had an offer as a senior diplomatic post abroad, which was withdrawn due to the cost of providing the necessary support for her disability. The applicant pointed out that the employer had a policy of paying £25,000 per year for school fees for employees with children, but costs above £10,000 for support for disabled employees were discretionary, and this discretion was not applied in her favour. The AT concluded that comparing her to a disabled employee with children was inappropriate as their needs were different. The tribunal's decision was upheld by the EAT, who concluded that it was based on cost and not the disability, being the reason for the withdrawal of the job offer. The EAT did not need to determine who the appropriate comparator should have been in this case. And lastly, the relevance of abilities of comparison. The disabled claimant and comparator must have the same material abilities, and thus under Section 23(2) of the Equality Act. Next slide, please. So essentially, discrimination because of a disability, this includes where an individual has been treated less favourably because of their disability. In such circumstances, the tribunal would consider the reason why the claimant was treated less favourably, what was the employer's conscious or subconscious reason for the treatment, and the reason must be the disability itself and not merely something related to the disability. I'll now hand back over to David.
Thank you, Medina. And yes, I think that's just following on from that. The comparator issue is again something that we have probably seen a lot of incorrect choice of comparators. I think some of the ones we have seen recently is, someone who's several tiers up, so senior management versus a junior employee. It's both circumstances of the disability or the protected characteristic and the role that they're in as well. And again, that can cause problems. So, Julie.
Thank you, David. I think the other factor in terms of direct discrimination, it comes down to this causal connection. It's not sufficient for an individual who has a disability to say, here I am, I'm this, I am an employee here, I have this disability and I've been treated like this, so it must be because of my disability. There has to be a causal connection, and it is the claimant, the employee's responsibility to be able to satisfy the tribunal of that connection. And I think it's that element that makes it so difficult for an employee to succeed on, because it's very rare, for example, for an employer to treat someone less favourably because someone has a particular condition or a particular, a bad back or, another fibromyalgia or a condition that they have. It's more likely that that it is something entirely different. It still might be unfair, but it's something entirely different. And I think it's that when you get a direct discrimination complaint, that's the bit that you need to focus on. There is no causal connection between the disability and the alleged act. Thank you.
Thank you, Julie. And yes, and that is very important. And one last thing before we move on to indirect discrimination is direct discrimination. There's really no justification. You other than age discrimination, which is a unique element when it comes to this. If the tribunal finds that there is a direct causal link, or the employee or the claimant can provide that, you can't justify it. There is no legitimate justification defence when it comes to direct discrimination. But then at the same time, they're quite easy to defeat in the sense of, well, no, we didn't do it because of this protected characteristic, disability, and so on. We did it because of X, Y, and Z reasons which aren't linked to their protected characteristic. So it is either a whole, they've won everything, or they fall over at one point, and then unfortunately that is that direct discrimination claim gone. Next slide, please. So the other element to then start looking at is indirect discrimination, and this is a wider remit and comes with a different gambit of issues for employers and employees. So obviously for those, it's A, which is usually the employer in this situation, applies to B and others a PCP. Provision, criteria, and practice akin to a policy. And B has a protected characteristic, obviously in this situation, disability. And that application of that policy or PCP applies to everyone. So on the face of it, it looks neutral. but puts that person or that group of people at a disadvantage because of that protected characteristic. So, for example, you might have everyone needs to be physically in the office by 8:30 in the morning to start work. On the face of it, looks perfectly fine. Obviously, I'm moving out for disability. You might have someone who can't get into the office for 8:30 in the morning because of their disability. There is a potential disadvantage. Or still women who are primary carers, still for children, they have the school run. They can't get in until 9 o'clock in the morning, for example. So the policy in on itself, it looks fair. But actually, when you put it into practice and you understand actually how it works, there's potentially disadvantages for groups of people. And you cannot justify the reason for that policy being in there as a proportionate means for a legitimate aim. And I think number 6 is the vital important one here, and I'll talk about it again later. But this is, why are you putting in the policy? What are you trying to achieve? And is there any other way you could have done it? And I think one of the important things to look at, certainly with claims for indirect discrimination, is your legitimate aim needs to be at the time that you have created this policy, this practice, this whatever it is, not later on down the line. You're not trying to shoehorn a rationale in later, going, oh yes, that was the reason that we wanted to do this. You need to be understanding that at the time you're putting these PCPs in place, because the tribunals can and do see through them, going, well, you're clearly just trying to justify something you hadn't thought about. And I think that is the thing where you're looking at it. Policies are easy. People can put in policies quite easily on a whole range of things, and employers do. But a PCP doesn't have to be a policy. And I think that's something to think about, is they also can be relatively unique. They can't be unique to an individual because there's not then the group disadvantage, which we'll talk about as well. But that's where this is where the nitty gritty of an indirect discrimination claim comes, is what is this practice? Is it applied to a group of people? If it's not applied to a group of people, it's not easily going to work. And then does it put that a group of people at a disadvantage because of a protected characteristic? And that's the other thing people need to show, is a group disadvantage, whereas, which will be in the next month's session, reasonable adjustments are very personal, which is why they're a lot easier to win than an indirect discrimination argument. So next slide, please. So just obviously going on, I've talked about this a little bit. A PCP doesn't have to be a formal policy. I mean, a lot of the times it does flow from that. But we have seen a lot of people, obviously, you've done something which is an informal management decision. It affects my team. I'm disadvantaged by it. There is a PCP. An example would be, it's not necessarily a policy, but I've seen a lot of law firms recently are saying, well, now to qualify for your bonus in the next financial year, you have to be in the office 3 days a week to qualify for the entire year. Now, on the face of it, people are not going to be happy with that, because I have to come into the office. It's not discriminatory on the face of it, because you're not saying X number, this group has to come into the office. So if you said all disabled employees have to come into the office to meet your bonus targets, well, that's a direct discrimination claim, because you're doing it because of a protected characteristic of disability there. But it could actually impact indirectly, like we said, people with disabilities who can't easily travel, or those with caring responsibilities, for example. So they have to think about it and as to how it can work. So this is something that comes up quite a lot, and is the meat of an indirect discrimination claim, is the PCP and how it applies. And I'm sure Kit, Julie, and I can all sit there and tell stories of how we've sat in preliminary hearings trying to work out what on earth the PCP actually is from the claimant, to then work out what the legitimate aim was from the employer. And that is the thing that tribunals will grapple for ages. Knowledge is less required really for this, because it's not aimed at a specific person. It's could it affect disabled people, or could it affect women, in the generalistic view is kind of what's there. But the important thing really is the group disadvantage, and showing that it's not just you that's been disadvantaged, but everyone who shares that protected characteristic to a point. Now, next slide, and this is the change in law that I was talking about earlier, is the new section 19A. Well, it's not new, it's been in the Equality Act since it came in, but it's now come in as in 2024, sorry, it's now come in, and it means people who don't share the protected characteristic but do have the disadvantage can also potentially now bring a claim. So a lot of people are saying it's indirect discrimination by ricochet. I might not have the disadvantage of disability, someone else in the business does. however we're both suffering from it, I could tack on to a claim saying I've actually been discriminated against. And it's quite interesting. I've yet to see actually any cases land on this, but I think it's something to be aware of, that now your legitimate aim is wider when you're thinking about things. Why are we doing this? What is the reason we want to put this policy in place? What is our legitimate aim, and have we thought about any other way we could do this that isn't going to impact as much as this one is? And again, it will probably come up in the reasonable adjustments one, but tribunals go further in their thinking than you think they will. I've seen some interesting decisions where a tribunal goes, have you thought about this? And a witness goes, actually, no, we didn't. And then suddenly you're in a little bit of difficulty. So it's something to be thinking about. So I think just for here, for example, looking at how this could work really is, again, going back to someone requiring them to work 9 to 5 in the morning. This affects, hypothetical here, more affect women because of their caring responsibilities, for example. There's an indirect discrimination claim there. I'm suffering a disadvantage as a man who doesn't have caring responsibilities. I can then tack onto that claim, and suddenly you've got an extra claimant to deal with, an extra compensation. So it is something to be very aware of, and as to why you are wanting to understand what you're doing. Next slide, please. So obviously, this is the key defence for an employer, the objective, justification and proportionality test. What is your legitimate aim? Why are you doing this? What are you trying to achieve? And is your business need or health and safety need? That is part of it as well. What are you trying to do? If you're trying to drive up attendance in the office, that's an understandable aim. But is this the right way to drive up attendance in the office, for example? And then is it proportionate, appropriate, and necessary? So basically, what other ways can you do this? Is there a different way you can do it? So, we want people in the office 3 days a week, fine, but start times can vary because of people's travel requirements. There you go. That's a slight amendment to that policy. Still potentially gets people in the office, but also deals with those that can't necessarily get in for 7 a.m, 8 a.m, whatever time you've said people need to get in. And I think one way of looking at it is it's not a reasonable adjustment, but sometimes looking at it as a reasonable adjustment. Is it actually going to get people back into work in the way you want them to? And is there another way of doing it that's not going to cost a lot of money or is not going to cause a lot of problems? So it's probably the one way of looking at this when you're trying to work out actually what is my legitimate aim and the proportionate test for doing it. And like I said earlier, this is something you need to be doing at the time, not 6 months later when you've got a tribunal claim on your desk and you're trying to work out actually what was the reason we were doing this. We need to create something, because tribunals can and do see through that quite easily. And effectively thinking you should be, is there a way we can make sure this doesn't discriminate or discriminates less? Tribunals do accept that, for indirect, some discrimination happens. That's unfortunate. It's life, it happens. But is there a way that you could have made that discrimination less of an impact? And if the answer is yes, you need to be looking at that first before you go to the original what decision you wanted to have put in place. So next slide, please. So we're just going to Julie, before we move on.
Yeah, sorry, I was just going to come in on the objective justification. I think most of you within the public sector will have a head start, as it was, in putting together your objective justification reasons, because most policies, procedures, most criteria, most new initiatives, you will have gone through an equality impact assessment, and you'll have assessed the impact, as far as you can see it at that point, on various protected groups. And I think what I would do in all cases where you have a directive that could potentially impact, obviously from the outside, could potentially impact on certain protected groups. In this session, we're looking at people with disabilities. Then consider carefully how you would answer those questions when you put the criteria in practice, and don't wait until you get the tribunal claim and then fill in the blank. So consider what is your legitimate aim, and make it really clear why you're doing it and why something a lesser initiative, something less discriminatory, won't have a sufficient impact, won't be successful in meeting your aim. If you can put all that in place, it's difficult then for the tribunal to say, well, we don't think that that's sufficient, because they're not allowed to stand in your shoes and make different points. They've got to look at what you've done, and they've got to understand your justification. So that's, I think, as I say, you've got that already, but retain it in terms of how you put things in place, and make sure you cover those questions. Thank you, David.
Brilliant, thank you. So we're just going to look quickly at some case law that's kind of been around in relation to discrimination cases. Now, obviously, as many people know, no one really ever brings the case for pure direct discrimination unless they really are just terrible at writing their claims. There's usually going to be a suite of, certainly with disability, direct, indirect, reasonable adjustments, and usually something arising from, which those two will be covered next month. So a lot of these things will seem like they fit in a lot of these groups. So Raj was a case where Ms. Raj joined Starling Bank in July, as it says, and she passed her probation. And again, I think this is kind of some of the important steps you see. They pass key milestones, and then suddenly something happens, and employers then fall over because some things have been known beforehand. At this point, she unfortunately developed a chest infection and started working at home because of that condition, and it was easier on her. And it developed and it got worse. And she took sick leave because of developing asthma, and she had x-rays and everything else, kind of what an employee would be doing in these sorts of situations. And she was communicating this with her manager, basically going that there's issues here, I'm not well, this is potentially what it is. So, and I think, remember that bit, she was communicating with her employer here. So next slide. What did Starling Bank do to this? Well, the worst possible. I think they ended up dismissing her. In February 2020. Now there were delays here, as it says, because she was taking annual leave, and there was also her health issue that was going on, and kind of working around that. And the main point really that they were saying was, as it says at the bottom, she was not Starling Bank material, whatever that means. It's one of those throwaway lines that some employers use, you're not this. But the problem here was there was a developing issue in relation to her health. And that, she needed time away from the office, whether both off on sick leave and or that she wanted an amended working pattern, i.e. working from home, because of her asthma. And she was saying it was due to the air conditioning within the workplace that was causing a significant problem to her health. And she contested, the employer said, no, you've never told us, this is silly, what do you want about? HR also asking her to speak to her manager about her asthma issue, and it's basically degraded from there, and like you said, she was dismissed. So next slide, please. Now, obviously, one of the points here, it does say she was dismissed for arising from, it was unfavourable treatment from something arising from disability, which is a slightly different claim. But also there were elements in relation to, she was subjected to a detriment in relation to her disability, which was her ongoing asthma issues, which clearly were going to look like they were going to go for more than 12 months, and kind of really didn't help. The Starling didn't help itself here, because effectively the policy in the PCP here was her working in the office, and she was put at a disadvantage, and other people who had asthma would be put at a disadvantage by working in the office. And there was no legitimate aim in forcing her into the office that they could demonstrate to show we need people with, effectively, we need people with asthma in the office, in the air conditioning. It was exacerbating their medical condition, and we dismissed her for it. So an indirect discrimination claim, and others as well. And I think part of that is, keeping an eye out as to what actually you're trying to do. Now, getting her in the office, understandable. Do you want her in the office in a different location? There you go. You could potentially get her in, and she wasn't sat under an air conditioning unit, for example. So I think this is what, like Julie was saying, was where are your business decisions? Where are your rationales here for these sorts of decisions that is actually going to get someone to do what you want them to do? Because it's not always about office attendance, but it's just be careful as to what's happening and what decision, because obviously in this one it went horribly wrong for the employer. and they lost on several cases, several points, and obviously Ms. Raja was successful. So again, I think it's more of a lessons learned as to be very careful as to how indirect discrimination can suddenly raise its head when you're trying to get at what you think is a legitimate decision, which on the face of it probably is, but without looking at the impacts it can have on groups of people. And I think certainly, and before we move on, the big one is the unknown or the hidden disabilities that can catch you out very quickly because you don't see it. Going to be able to see it. You can see someone who has got a physical disability who struggles to walk, for example, and most people understand what they do with that. Someone with a hidden disability, which is a huge remit of what that could be, people might struggle a little bit more. So it's again legitimate interest. What are you trying to achieve, and is there an easier, less discriminatory way of doing it? Next slide, please. And before we move on, Julie, sorry.
Yes, I was just going to say, in respect of indirect discrimination in that particular case, I'm aware a lot of our clients have, since the COVID, tried to encourage staff back into work and may well have a minimum number of days they're expected in the workplace. There are a lot of really good reasons for that, certainly as local authorities, that you're part of the community, you need to be seen in the community, you need to be using community facilities, all those sorts of things. So there are a lot of good reasons. But when you have that type of blanket policy, it's a really good example of what I was saying earlier. Ensure that you've considered if there are any lesser means of achieving that, because we can no longer rely on the argument, well, you're a manager, you can't do your job at home, because for 2 odd years over COVID we all did, and some people more successfully at home than in the office. So I think you can't fall back on the previous arguments that organisations, employers used to run in terms of what is feasible in the workplace now. I think you then have to consider whether that blanket policy should apply to everybody, and if so, how can you justify that? Thank you, David.
Thank you. And just before I move on to Medina, sorry, again, with that, there was a case a couple of years ago. It was an indirect sex discrimination argument and a flexible working argument of a senior manager. I think it was in HMRC. I can't remember off the top of my head, but she brought both arguments because she had put a flexible working request in, and the employer had done the proper piece on all of the work as to why they wouldn't say she could work from home permanently, was because she was a senior manager. She was required to be in, but that team had to be in at the same time because they needed to work with her on projects, on certain, on days, and to cascade the experience down. And I'm sure a lot of places are like saying, well, you need your juniors, your training, people who are new to the job and training need to be in every day. But then you don't look at the other side of, have you got senior people in at least every day to keep that support going, and finding that middle ground. Now, HMRC did it properly. They did this whole, no, it's not no permanently working at home. We need you in part-time because of these very important reasons to get it going: the training, the delivery, the engagement with other people, and the tribunal actually commended them, saying they'd done that piece properly. It wasn't a blanket policy if you need to be in. There was that policy, but we've now looked at it and considered the situation. They fell over because they didn't actually do the flexible working request quickly enough, and that's again just something to be aware of, where flexible working requests again can quite quickly flow into an indirect discrimination argument, generally around sex and disability, because that's where you see a lot of people needing these sorts of requests, childcare requirements, certainly after paternity leave, for example, or disability like we're talking about. There's a reason they can't be in the office every day. So they can again come back of hand for a flexible working request. So again, just something to be aware of. I'm sorry, I'm now passing over to Medina. Sorry.
No worries. Thank you, David. So where are we now? Disability discrimination claims now make up a quarter of the total number of claims that are referred to ACAS for conciliation. There's been a growing awareness of mental health issues and lagging policies. While awareness of mental health challenges is an all-time high, many organisations are behind in developing policies that adequately address these issues. And this gap between awareness and policy development can leave both employees and employers vulnerable in handling mental health issues. So employees need to better understand their responsibilities from a legal, ethical, and business perspective. And it's essential to understand these responsibilities are not just about legal compliance, but also about fostering an inclusive and supportive workplace. Organizations need to ensure that managers are confident and have capacity to manage people effectively. And as managers are often the first point of contact for employees facing health challenges, including mental health issues, providing managers with the right training and support is essential, as it enables them to confidently navigate these issues and offer the necessary support. So where there is a disability that leads to performance issues or sickness issues, it's advisable that employers should seek advice from HR or seek legal advice early on. Thank you.
Thank you, Medina. Next slide, please. So just very quickly covering, obviously, disability harassment. So harassment is a slightly interesting concept, and I think this is what we were talking about earlier, where people get it wrong. Certainly employees get it wrong, because obviously there's the employment law definition of harassment, which is on the screen, and then there's the criminal definition of harassment in relation to a course of unwanted conduct. And I think a lot of people say that's harassing me without actually understanding what they mean. You know, someone's emailing me and it's harassing me. Okay, that might be unwanted conduct, don't get me wrong, but is it actually related to your protected characteristic, and is it employment harassment? So obviously, is there, it's unwanted contact related to disability, please insert other protected characteristics as necessary. And there is that conduct of it violates that person's dignity, or it creates a hostile and degrading environment in general. So it can be both, and this is where you kind of sometimes see the indirect harassment claims, I think is the best way of putting them. So and that's more in the sense of, so two people are having a conversation in the office, the lovely phrase of they're having banter together. There's nothing wrong with that conversation per se between the two of them. It's adults who are having a conversation, might move into areas of unfavorable comments, but between them you don't see a problem because they're both happy about it. Someone overhears that conversation and then saying it's creating a hostile, degrading, or humiliating environment for me to work on, it's therefore violated my dignity on my protected characteristic of X, Y, and Z. And I think that is where also we're seeing them occur more and more, is these conversations, because people, you joke around in the office, people, no one's trying to clamp down on people just being able to talk, but again, it's something to be very careful of. And it also is getting worse, and it will be part of this later on, is the new laws on sexual harassment. Now, I will move on to that actually properly, but it's just, again, this is where this comes in, is the second test really, which is the environmental impact, for lack of a better phrase. The wider, the voice travels and someone hears it, rather than actually person A doing something to person B and saying offensive comments or things like that. So it's something to be very, very aware of that's happening in the workplace. So next slide, please. So again, obviously, just a reminder of who it covers. It's employees, workers, occupational and volunteering training. Basically, it's going to cover a lot of people. So just be very, very aware of that. And also, whilst it's still not fully there, the perpetrators can be a wide range of people as well. It's not a limited perpetrator. It's not just the managers. It's not just the business. It's anyone and everyone can kind of lead into this. So it's just, again, how wide it can impact a business. So next slide. Very very quickly just cover again what a disability is for those that need it. It's physical or mental impairment, and it has a substantial long-term adverse effect on someone's abilities to carry out day-to-day activities, and has at least 12 months, has lasted for 12 months, or is likely to last for 12 months or more. So it's just that's there. Quickly covering other diverse protected characteristics. Sexual orientation is obviously one that people are aware seems to be continually growing, as is religion and belief. So obviously most people understand the major religions, but obviously minor ones as well. And lack of religion or belief is also there, as long as holds a key weight within society. So again, who this could impact is continually growing. which I think a lot of people, if they're rolling their eyes at, going, great, it's just more and more people are now going to bring claims. Not necessarily, it's just be aware that policies and things can have a wider impact than was accepted. Imagined at the time. Next slide, please. So this is a slightly odd one when it comes to disability, and it potentially applies to protected characteristics in and of itself. Perception of a disability in and of itself can't lead to a harassment. Now, so this claimant was in this case, they didn't actually have the disability. Someone just assumed they did, and they failed to bring a claim because there was no real knowledge. It was, wrongly perceived to have that disability, so it's difficult to say they were subjected to actually because they had it. Now, it's a little bit of a leapfrog argument, I'll probably accept, but it's just something to be aware of. Doesn't get you out of it, but it's just it's something to be aware of. And obviously, where you get the issues is the non-visible or non-apparent disability. Certainly, the claimant, and this is what Julie was saying earlier, the claimant must prove they have that protected characteristic, and then prove that treatment was because of that protected characteristic. So I think it's just things to be aware of going forward, and other arguments, and I think we do talk about it later, but I think one of the cases that people will have recently heard about is the bald man who was, I think he was called a bald git or something like that by a colleague. He was successful in his sexual harassment claim because he was able to say, well, actually men do suffer baldness more than women, so therefore actually I have suffered a disadvantage based on this, and therefore it is harassment, it's degrading. And a lot of people were like, how on earth did that claim succeed? But actually you could understand how it happened, even though the employer was like, well, women do unfortunately suffer from baldness as well. It's not really harassment in that sense, but it's something to watch and be careful of. And I think as the next slides will go on to, what can actually be this unwanted conduct and where your problems arise from. So next slide, please. So this is a non-exhaustive list. There's 2 slides on this just to kind of say where it goes from. Spoken words is the obvious one, and the banter. Banter is probably, people loved it originally and now becomes the bane of anyone in HR and legal's life when someone says, oh, it's banter. And because sometimes it is fine, other times it very quickly goes wrong. The written word, that is a big problem, purely because a lot of people can interpret things quite easily and misinterpret things quite easily with the way things are written. I'm sure we've all been guilty of saying something in an email which we think is perfectly fine because you're busy, you're trying to get something off, and someone misinterprets it because they're seeing a very stern email. Obviously that's not necessarily harassment, but it's just something to be alight of. And usually at some point in training, I always like, when it comes to emails or things that are recorded, I say, my favorite phrase always used to be dance like no one is watching, and write it like you're explaining it to your parents. Or now with what's happening in America, you've had a journalist join to a group chat about plans to invade another country. You don't want someone seeing it like that and misinterpreting it. So just be very careful as to how things are written. It goes further. So social media posts, everyone might remember the BA case a few years ago, Heathrow case about the gollywog. That led to a harassment claim. Use of imagery, I've seen that for other clients, about imagery put up in the office and it's alleged harassment. Graffiti, again, that becomes very difficult when you've got public offices. People can go in and use toilets. I've seen that in places before, during, for example, LGBT History Month, adverts about it in the public toilets and people scrawling offensive words and graffiti across the posters. And it's got employees pictures on there who are talking about their life history. And again, with other months that happens in as well. Physical gestures, I think, is really the obvious one here. We can all probably think of physical gestures which are unwanted and offensive. And next slide, please. Facial expressions, mimicry, jokes and pranks, affects a person. The list goes on. And like I said, this is a non-exhaustive list, so I feel it's very doom and gloom as to where it can come from and how it can be interpreted by anyone and everyone. So the next slide, please. Another case here on indirect discrimination. And this was a person, Mr. Harris, was suspended. There was an issue that led to a suspension. but this person actually had learning difficulties and didn't really understand the suspension. And this is where the issues was there was actually an impact on the reason for suspension was legitimate. Everyone understood that, but actually the suspension and justification, it was an issue here because of that person's inability to understand. So the policy of suspending people for certain actions in and of itself was neutral to a point, as the suspension is, but actually had a greater impact on this person because of their disability. So they suffered a disadvantage. And the EAT did say here, but for that, if they didn't have that learning difficulty and issues and comprehension issues, a suspension would have been fine and wouldn't have constituted harassment and other issues. It was in this situation because of the very nature of this person and the learning difficulties, which is where it came up. Next slide, please. So also we can have harassment and issues related to disability. So again, it's conduct towards them because of their disability, but also it can, to a point, cover others. So this is discrimination by association element, is if you're a carer for someone with disability and you suffer harassment because of that, it can be caught because you are dealing with someone who has got a disability. You just need to be careful. Now, obviously, that impacts quite a few carers quite a lot in the workplace. And so it's just something to be very aware of as to how disability, I think more than any of the others, is this association with someone. And there have been cases, where a person is looking after their disabled child and someone says something, and whilst they themselves don't have that disability, they are looking after or associated with someone who does, and that's where you can cause issues. And I think, again, like it says, conduct related to others, it's witnessed by others. It's where that growing harassment claim is of that environmental issue of someone says something, someone makes a joke about disabled people or other protected characteristic. People, the person's actually disabled might take part in that joke and find it funny, but someone else overhears it and doesn't. And that's where, the age-old banter issue is expanding. So next slide, please. I think a good place to look at for anything in relation to disability and harassment is the EHRC Code of Conduct. They have really good examples, and it has been expanded quite recently due to the sexual harassment changes in the law, of just kind of looking at what can constitute harassment, disability, discrimination, and so on. And this one here is quite obvious. This is the association one. Because she herself was not disabled, or the worker, was not disabled. Their son was, by their facial scarring and severe disfigurement. They were offended, and rightfully so, by that person's jokes in the office. So, if you're not sure what could be, and again, the Code of Conduct is not an exhaustive list, it's just an idea of where these sorts of banter issues and so on could come from. Julie.
Thank you, David. So I agree. It seems like it's disability, associated disability, but the definition of harassment is related to our relevant protected characteristics. So it doesn't have to be that employee doesn't have to be disabled. It could be that, as you say, they've heard comments that they find offensive just because they find them offensive because they're about disabled people, or it could be about someone that they actually know. So there is that. They don't have to prove that they have the protected characteristic in order to succeed. I think in what we often find in employment scenarios, and certainly with our clients, is less of the banter, that side of it, the comments, and it's more in terms of actions which the individual considers or harassing. And it often comes out, for example, if somebody has to have a lot of sickness as a result of their disability, and the employer then takes them through a sickness management process. Employees find that sickness management process, the formal letters inviting to a meeting where they may result in their dismissal, to be harassment. And it's that element that I think is key, looking at how you actually ensure that your processes are set up in a way you continue to do them, they're fair and consistent, but how you actually do it to ensure that it comes across fair and reasonable in the circumstances. Thank you, David.
Thank you. And that seems to be a perfect segue into actually the next slide, which is harassment and sickness. So next slide, please. So again, this is just some other ways that can deal with harassment cases when it relates to sickness. So the first one, normally, obviously, it's, you know, a colleague or a trade union rep in certain meetings. This person was not allowed to bring their mother in as the support. And that was found to be harassment based on that person's disabilities, and I think it was again learning issues, that mother would have actually provided critical support in that meeting that actually could have assisted. The employer said no, and actually that was found to be a harassment because it created an intimidating environment for that employee. Claimant was on long-term sick due to anxiety in Sainsbury's case. There was a social media post about International Men's Day, and it included a lot of store managers, but male managers, but didn't include him. And he was successful in relation to saying that was harassment based on his sex, which is, quite an interesting one. But again, it's just how these sorts of things can arise. And next slide, moving into disability harassment and hybrid working. So this employee required to be a home worker because they were primary carer for a disabled mother, and they wanted her in a lot, and it just didn't work. And again, they were saying, it was harassment based on certain characteristics. Obviously, again, these cases are going to have other claims as well, but looking at the harassment element, this is the point on this one. They were aware that this person needed hybrid working because of their caring responsibilities, and it created a degrading environment to try and force them back into the workplace. There was a harassment element in this as well, and I'm sure lots of employers and HR people will have seen some tribunal claims which list arm length claims of harassment. I a few years ago dealt with one that was direct, indirect harassment, and victimisation, and each one had like 36 points of harassing behaviour, indirect discrimination behaviour, victimisation behaviour. People do try and tally these up and think it will somehow make it more successful. But again, it's just what we're seeing is the trend. People are becoming more and more aware of how these claims actually work, and are getting better at articulating them. So again, just be very aware when you're making decisions, or people are putting actions in place, of how it might be perceived. So very quickly moving on to just the sexual harassment point, and harassment related to sex. Now, so next slide, please, Andrea. Obviously, there's harassment related to sex, which is a protected characteristic, and we're only quickly talking about the sexual harassment element here, because obviously there's the new positive duty to prevent sexual harassment in the workplace, and there is the new uplift of 25% on damages should the claim be successful and the tribunal finds that you didn't take all reasonable steps to prevent that sexual harassment from taking place. And we want to really highlight what it actually means, I think, in practice. So sexual harassment and harassment related to sex. So harassment related to sex will be things like all men are philanderers and things like that. It's a generic statement about men, for example, or about bald men or things like that. That's harassment related to kind of the protected characteristic of sex.
Yeah.
Oh, am I wrong there? Oh, sorry, Julie. And then but then things like sexual harassment are where it's become of a sexual nature, and that's where it becomes the enhanced duty situation. Now, it is a very difficult and fine line to walk, I appreciate. It will be difficult for employers to navigate, and employees to know. And I think for a while there'll be lots of claims of people saying it's sexual harassment, and actually it's harassment based on sex, or vice versa. So it really is, the starting point is looking at, is it making crass jokes about women in bed, for example, or men in certain scenarios? That's potentially sexual harassment, but it's just something to be aware of. Julie, sorry.
Yes, I think one of the key reasons why we've raised this in terms of the new laws of prevention against sexual harassment in the workplace is that there are there is proposals in place to extend that law, prevention of harassment, to other forms of protected characteristics. And from that perspective, any of the work that you've already done to put in place your measures in terms of the positive actions you're doing to prevent sexual harassment in the workplace, it is a good idea at the moment to be rolling that out across all areas of protected characteristics.
Thank you. And certainly when it comes to sexual harassment, but all EDI training, keeping a very good log of who's done it, when, and following up to make sure people have done that training. I'm very appreciative of the time, so we will move on as quickly as we can. So kind of really now looking at things in practice for employers, you know, what should you be looking at and so on. So next slide, please. So like I said, all reasonable steps came in October last year. Like Julie said, it's going to expand sexual harassment. They're even looking at it from, you know, in the Employment Rights Bill, they want to make it for individuals off the street can sexually harass employees and workers. It's going to get a lot harder for employers to control these sorts of things. So be very, very aware. But still, you need that fundamental link. You know, it's not just a free for all claim. So next slide's on, and basically key takeaways here really is, obviously, as it says on the tin, stop treating people less favourably because of a disability or a protected characteristic. I mean, it's an obvious statement there, but you know, making sure that your hiring, your promotions, your decision making are not based on that protected characteristic. You know, be careful with that. I know in most local authorities, I mean all local authorities, I don't know what I'm saying, some aren't. All local authorities have very good, robust practices for doing that. You know, there's blind sifting, there's multiple ways that things are looked at, and you know, the equality impact assessments. But just be aware of these sorts of unknown elements that, you know, actually, is this the best policy? Is this the best decision that's going to get people involved in that? Look at your legitimate aims. I think that is your key point for indirect discrimination. Make sure your legitimate aims are there at the time. What are you trying to achieve and why? Don't look at it later. Don't try and shoehorn and go, oh yeah, that was probably the reason we wanted to do this, that will do it. Tribunals, if you're in that situation, do see through it. So you don't want to be on the shoehorn of like, well, actually, is that the decision you had at the time? Is that why you wanted to do it? So be very, very alight to that. And if you're struggling with that, speak to your lawyers, speak to your HR teams when these sorts of things are coming through as to, is this actually going to work the way we want it to? Like with any of these things, foster environments of support with your employees with disabilities, other protected characteristics. You know, don't make assumptions about things. I think assumptions, you know, it makes an ass of you and I think it's the colloquialism there. It does cause problems, and again, communication is always key in any matter. I think nearly every tribunal claim starts off someone didn't communicate properly and then it got worse. And being transparent and clear, making sure that you are dealing with reasonable adjustments. I know it segues into a lot of this, but in and other policies, you know, why you're making these decisions and what's going on. Next slide, please. Like I said, obviously this relates to all protected characteristics, some more than others. You know, disability, sexual orientation, religion and belief, I'm just thinking off the top of my head, are the ones that are very expansive as to who can fall within those characteristics. Probably race and racial origin, again, is another one. They are not simple delineated issues, you know, and obviously many people will fall into multiple protected characteristics. We've all got protected characteristics, and I think that's something to be aware of, is everyone has a protected characteristic, at least one, if not many. So, you know, it is going to affect many people. Again, I've added it, legitimate aims must be at the time and not added later. And said the new one of the groups that can be impacted has grown, with 19B being in. If you can show that you can also suffer a disadvantage, but you don't actually have that protected characteristic, they can still potentially bring claims now, and it's going to get difficult and harder for people to look at. So I appreciate the key takeaways there have been a very whistle-stop tour, but appreciative of the time. So Julie, and then obviously if people have got questions or discussions they would like to raise. So thank you.
Thank you, David. I think one of the key takeaways I would take in terms of looking at the type of claims that we see in employment tribunals on harassment one of the key things is manager training. By virtue of the size of your organisations, you often have very junior people who are managing staff, and ensuring that they have either sufficient knowledge and training to deal with individuals who may need additional support, or may have time off, or may not be able to do their full job because of a disability, or that they have a very clear and very prompt connection to your HR team, so they can ask before they do anything. Because what we ordinarily find, as I say, is it's the method of communication often that is considered harassment. So the method of communicating about somebody either not doing their job to the level that the manager wants them to do, or the amount of sickness absence. So the formal letters often can come across very very strict when somebody, for example, if somebody is off with anxiety and then they get a letter saying, you know, if you don't come to this meeting, you're going to be dismissed, sort of thing. Every letter that goes out has to be second guessed and considered, and ensure that it's that the language in it is fair and reasonable and necessary, and you can justify what is put in there. I think in terms of they're the sort of issues that we see most, and it's inevitable on times where managers do get frustrated, and that sometimes comes out in emails or in letters, or they're defensive in meetings of what they've done. And I think that's where the training needs to go. That would be my advice anyway. But thank you very much for listening. Thank you for David and Medina. If you do have any questions, please do either put them in the chat box, or wait around. We can stop recording now if you want to do that. The next session next month is on reasonable adjustments and disability, something related to disability, which I believe I am leading on. And you are very welcome to come back to join us for that. But unless there's anything else, thank you very much for joining us today, and I hope you enjoy the rest of your week.